We've talked a lot about preservation throughout the program, so we'll touch on that again, but I know that pretty much all of the judges I work with now are saying that a Rule 502D should be standard. I know Judge Peck in New York calls it the get-out-of-jail-free card, and I'm going to hand that over to Judge Putnam and let you talk a little bit about that.
Yeah, Rule 502D in the Federal Rules of Evidence, just as an interesting tidbit, maybe Paul's aware of something else, but as far as I know, Rule 502D is the only federal rule of evidence or procedure that also applies in state court. Basically, 502D says if you have a massive amount of, in our case, ESI, electronically discoverable information, that might potentially have in it privileged information, attorney-client communications or work product information or something of that sort. Under traditional waiver rules, privileged waiver rules, if you inadvertently reveal that privileged information through production of the ESI to some other party in the case, then even that inadvertent production of it amounts to a waiver of the privilege. What 502D does is it provides essentially a rule-based equivalent to the old clawback agreement. Prior to 502D, lawyers used to engage in what was referred to as clawback agreements, whereby prior to the production of any kind of ESI, they would agree between themselves that if they, in producing the ESI, they inadvertently produced some privileged material, that it would, by agreement, it would not be a waiver of that privilege, and that the lawyer could notify the party to whom it was produced and get it back. And that's what 502 attempts to accomplish. That is, if in a federal proceeding, whether it's an administrative proceeding or a court proceeding, if in a federal proceeding a party produces information, documents, ESI, and it contains privileged material, and the circumstances of the production were such that the inadvertent production of the privileged material was not unreasonable, then under 502, it's not a waiver of the privilege anymore, and there is a procedure established for the material, the privileged material, to be gotten back. So the interesting thing about 502D is that it also says that not only can that inadvertently produced privileged material not be used, would not be a waiver in the litigation in which it occurs, it cannot be used in other litigation, even state litigation. So the purpose of 502D, when you're dealing with large amounts of ESI where there may be privileged material in it. Now, conversely, if you have a relatively small amount of material whereby it would not be unreasonable for you to actually review it all before you produce it, then you may still have a waiver problem. But under 502D, in the recognition that in ESI situations, you have millions, if not tens of millions, of potential pages of information that's going to be produced, it is simply not reasonably feasible to conduct a privilege review of that material before the production occurs. And so you necessarily, in producing ESI, you necessarily run the risk of producing privileged data, privileged material. So the purpose of 502D is to give you an insurance policy, basically, that if when I produce this massive ESI, if there's some privileged material in it that I identify later, then you can't use it, and I get to get it back back, it's not a waiver. And I'm protected also not only in this litigation, but in state litigation if that production occurs in the federal proceeding. Now, 502 requires the entry of an order by the court to establish that procedure. So 502 authorizes you to go to court, get a court order to preserve that protection of privileged material. And so it just strikes me that in any case in which there is a large amount of ESI or some amount large as defined by there's so much here that I really can't feasibly review it before I produce it, that a resort to a 502D order ought to be pretty standard practice, I would say.
I've heard some judges opine that they're trying to understand how it wouldn't be malpractice to not get one.
Right. There is, Melissa's pointing out to me that to the extent that you want a go-by, Judge Peck's order under 502 can be found on the ESI Roundtable website. It's there for you to download and suggest as a potential order that you can obtain in any litigation you have in. But as Paul said, it's becoming recognized in at least large data ESI cases that the failure to get a 502D order that then results in the production and subsequent waiver of privileged material can come out to malpractice.
Don't want to talk about Rule 37E. We'll move on to the last slide. We're going to address that in the federal rules on December 1st.
Yeah, I mean, that's going to change on December 1st, so it may just make sense to wait and talk about that on December 1st.
That's about the biggest impact on eDiscovery in the new federal rules amendment to Rule 37E.
Anything we say about it now is going to be obsolete.
In a month.